Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Welcome. Thank you so much for joining me today. Welcome. Thank you for joining me. We are just hopping over. We were over on the Karen Reed motion hearing. Now we're on another hearing, and that is a Jennifer Crumbley hearing. She is demanding an entirely new trial. This ought to be a load of fun to hear. So, oh, my mouse decided to slow down. There we go. So I already have it up and ready and already gained. It has already happened, but I heard it was a little bit on the interesting line. So let's hop in over there. Let's get rolling. The sound quality. The sound quality over here is going to be a little bit of an issue, but we'll be fine. Hi, out and about with Diane. Hi, Siva. How are you doing? Welcome. Thanks for joining.
All rise. The court is now in session. The Honorable Crumbley Matthews presiding.
Good morning, ladies, Stephen.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990 FH.
Good morning.
Thank you. Good morning, Mark Keith on behalf of people.
Joseph Shada on behalf of the people.
Good morning, Your Honor. Michael Desi, P64530, appearing on behalf of defendant Jennifer Crumbley, who sits at counsel table to my left. Also, Your Honor, by way of introductions, I have 3 law students from the University of Detroit Mercy School of Law who have been assisting me as interns, and I'd like to introduce them. Jackson Moore, who will be assisting at counsel table with the court's permission.
Sure. So I should direct all my questions to him.
Please do. Please. I asked him if he wanted to take it this morning,
yes.
and he said yes.
Okay.
So Jackson Moore will be assisting, and then of course Paul Brochet, who's also going to be assisting me.
Good morning, Judge. Good to see
Good morning.
you.
And then I also have my law student Nick Priolo, who's also here from the University of Detroit Mercy School of Law.
Welcome.
Beth Bentley.
That may be me one
Thank
day.
you.
I don't know yet. I'm kind of
Today's the date time set for defendant Jennifer Crumbley's motion for a judgment of acquittal or in the alternative, a new trial. As you're well aware, I have read everything frontwards and backwards and all the cases that you cited. I've read the motion filed by the defense as well as the response by the prosecutor. The court also allowed for the defense to file a reply. The reply of the defense is partially responsive to the response that was filed by the prosecutor, but also contains allegations not supported by the original motion filed by the defense. The reply references a public relations firm allegedly hired by the prosecutor, as well as media outlets shadowing trial preparation at the prosecutor's office. Any argument about PR firms or alleged gag order violations aren't the subject of the motion filed and aren't relevant to the motion filed. Although these topics are undoubtedly of great interest to my long-term friends who are from the press and may have some future potential relevance, they do not help me decide this motion. Therefore, I don't want oral arguments on these topics. I am, however, very, very interested in hearing arguments about the proffer. All right, Mr. Desi?
Sure. Thank you, Your Honor. Your Honor, if I may, just before we get into the housekeeping matter, I would ask that if the court, with the court's indulgence, Mrs. Crumbley has a very serious medical condition, a substantial hernia that is quite large. It's hanging from her stomach. And I would ask, with the court's permission, that if the belly chains could be removed from her, because those are putting a lot of pressure on her midsection where that hernia is, and you can see it visibly from her body.
I don't have an issue with that. Several issues with regard to Mrs. Crumbley were raised with the court last night, and we tried to take care of those with the jail. In addition, the deputies approached me this morning. I've been in the courthouse 33 years, and none of these deputies tell me how to try a case, and I also don't tell them how to keep me safe. So I would ask if it's possible to make Mrs. Crumbley as comfortable as possible, and as well allow her to participate in her hearing today. I don't really know what that involves. I don't think anyone thinks Ms. Crumbley's gonna make a run for it or anything like that, but I have to defer to the deputies. Can her belly chains come on?
Your Honor, I did speak with our jail director. I can't confirm nor deny whether their medical condition exists, nor can she. However, I will allow her belly chains to be removed for the sake that she does have this medical condition. However, the leg shackles will remain secure.
Thank you, Captain.
Thank you so much.
All right, we're gonna ask them to do that.
Y'all, when you have an extending hernia and anything that goes around it is excruciatingly painful, she needs to get that taken care of, and they can take care of that in prison. It just takes a long time. But I fully can understand that request. But yeah, that is unusual that they did that. I'm pretty impressed that the prison guards did that.
Mr. Desi, the court is likely in agreement with you that there's been a
Good for advocating for your client.
MCR.
Good job.
6.201.
I know,
I guess
and I
my
can't
real
wait to
question
see if
is-
she does it again.
Sure.
Let's
All right.
see.
Well, if
Y'all.
your honor is inclined to, if you're
I'm sorry, I'm hopping from one live to the next to the next. I got 3 lives today. So just to let you know that today's the last day that you can get involved in the drawing. And I mean, it is a good drawing. It's a $50 gift card giveaway. Subscribe and comment. iSub gives you an entry. Hit the like button. You get 5 more entries. You must hit ILIKED. I will show you that in a minute. And to become a member, you get 5 entries, and every super chat gets 10. So you can rack them up. The drawing, if you don't like Starbucks and you win, that's fine. I'll give you whatever gift card to whatever you would like. Okay? Thank you so much for that little understanding. We are now going to get into it. This is going to be good, y'all.
agreeing with my
Well, I
position.
said likely,
Okay. Well, I guess what
My
I'm,
job's to have an open mind, right?
well, the
Come on,
reason I'm
move.
asking is because the prosecution has made arguments that the proffer agreements were not cooperation agreements, did not confer any sort of immunity, and did not require or offer anything in exchange for these witnesses' testimony. I believe each of those assertions are false. And if the court would like, I would like to walk through the language of the proffer agreement to the extent that the court would like to hear that.
Sure, that's what I'm interested in, that, and the 9-page opinion we issued yesterday, I think we discarded some issues that we already felt strongly about after spending an incredible amount of time analyzing them, but I am concerned about the proffer.
Sure, I understand, and
I know
I
it's not something that I've dealt with a lot before, so.
sure. If we could put the screen up, I'd like to show the proffer agreements. That way it would be a little easier for me to walk through the language.
Okay.
That's
And I'm
fair.
going to ask Mr. Moore to put up Defendant's Exhibit A, which is one of the proffer agreements. And Your Honor, just for the record, the 2 proffer agreements are identical, so it doesn't matter if we show one or the other. They're the same, all right? They have
First, Mr. Ejak and Mr. Hopkins.
That's correct, for the 2 school officials. So, all right, just reading from the prosecution's brief, this is their response brief on page 3. This is what the prosecution says. Nowhere is in the agreements is there a grant of immunity or other agreement for testimony. They say there's no consideration in exchange for testimony. And the prosecution
right
also
back.
says that it is a gross mischaracterization of the proffer agreements to call them cooperation agreements. So let's just start first by looking at the proffer agreement, just so we can be clear about what the facts are. This is section 2 of the proffer agreement, and it clearly tells us that the purpose of the proffer agreement is to receive truthful information from your client, including information about possible criminal activity by your client and others, to evaluate your client's credibility as a source of information and potential witness. So as soon as the prosecution tells us that this proffer agreement has no effect and was not offered in exchange for any testimony, and it didn't even seek out testimony from them as witnesses, the proffer agreement directly contradicts that by virtue of the language that we can see right there in paragraph 2. So that would be the first thing I would say is the proffer agreement makes clear that it is for the point of evaluating the testimony for these witnesses.
Whether or not they were going to call them as a witness.
Of course, yes.
So do you agree that they could have taken the stand? Mr. Ejek and Mr. Hopkins both could have taken the fifth.
Absolutely, Your Honor.
And
And
violated the court.
they could, well, yes. And more importantly, now we're jumping a little bit forward to the issue of materiality. But as to the materiality, which we'll get
Oh,
to,
y'all, I love it.
the prosecution could not have secured the assistance of these witnesses, period, without the proffer agreements, because these individuals, by their able-bodied counsels, sought out and negotiated these
Oh,
proffer
what?
agreements so that they could go in with some assurance or
What? Did you say able-bodied? Whoa, I need to know why you're going there, dude.
protection that whatever they said couldn't be used against them. So
Use immunity?
use immunity, that's exactly correct, Your Honor. If Mr. Moore can move down on this. So the prosecution has continued to say the agreement doesn't confer any sort of immunity. I mean, it is completely puzzling how they could make that assertion, because right here in 6A paragraph, it says this office will not offer any proper statement made by you or your client in this office's case in chief in any criminal prosecution of your client. What does that mean? It means that those school officials who sat down with the prosecutor's office could say anything they wanted to in that room, knowing whatever they said could not be used against them at any later time. That is a grant of use immunity.
Yes, it is.
Only if it was true. You're correct, Your Honor. Only if it was
If
true.
they lied, that's wrong. Right?
That's correct. If they lied, then it doesn't. But the point I'm making is the prosecution has gone to great lengths to, in my opinion, gaslight us to tell us this isn't immunity. This is use immunity. I attached to my reply brief, Your Honor, a DOJ manual, a prosecution manual by the Department of Justice that describes in detail what these use immunity agreements are and proffer agreements. In federal court, we call them castigar letters with a K. In state court and federal court, we see them called proffer agreements. You've also heard them perhaps referred to as queen for a day letters. Okay? I don't know where that came from. I don't know who coined the phrase queen for a day.
I Googled it. Now I don't remember.
Well, I Googled gaslight, Your Honor. So I want to talk
It's a
about
movie from.
This is gonna get
1944. That's correct. It was a movie
spicy.
from 1944, Your Honor. And in that movie, if I could, and I just please, if you could indulge me for just a minute. In the movie, a husband married a woman who's had a famous aunt who had
Wait, that was it Betty Davis?
I don't think it was Betty Davis. The wife's name in the movie is Paula.
Does it
But
care?
the
Do
man
you
married
care?
Paula
Who
because
cares?
her aunt had lost jewels, and he wanted to get the lost jewels. He was trying to find her lost jewels. So he married this woman, Paula, so he could try to figure out what happened to the aunt's lost jewels. After they got married, he was searching around the house, creeping around like a cat. He was in the attic and he was walking, and the wife said, "I'm hearing footsteps." He said, "No, you don't hear anything, honey. You're making it up," because he wanted to tell her, to convince her she was crazy and needed to be institutionalized. And then he dimmed the gas lights. He was dimming the gas lights and flickering the gas lights. And she said, "Honey, the lights, something's wrong with the lights." And he said, No, it's in your head. The point is, now the term gaslight, I don't think we heard it before about 3 years ago, like 2 years ago, but we hear it all the time now. So I did take the time to figure out what it meant, but essentially stands for the idea that when someone's trying to tell you not to believe something that your eyes can see, they're gaslighting you. And that's what the prosecution is doing in this case by telling us that this agreement does not provide for use immunity. So why is it so important? Why do we care if this provides for
Perfect,
immunity
Libby.
or not?
You've been entered.
MCR
Everybody
6.201,
like the
if
video
Mr.
and
Moore
put
could
that
bring
in
it
there
up
so you
for
can
a
be
second.
entered for today's drawing for $50 gift card.
6.201, which is our discovery rule, which is the embodiment of the constitutional due process principles of both the Supreme Court's decision in Brady versus Maryland and Giglio. Those cases have decided that the prosecution has to turn over favorable evidence. So what happened? Perhaps the Michigan Supreme Court adopted this rule, MCR 6.201, that says upon request, the prosecuting attorney must provide each defendant, and then 5, any plea agreement, grant of immunity, or other agreement. So why is this important? Because we have now established that the proffer agreement, if you could go back to that, please. The proffer agreement provides for limited use immunity. So it is I don't even want to say it's my position. It's clear in the black letter of the rule that they had a duty to produce those proffer agreements upon request of counsel. Was there a request by counsel, Your Honor? Yes, there was. Mr. Jackson, could you put the request up, please?
They don't dispute there was a discovery request. They don't dispute that.
Well, I just want to make clear for the record how we link together the proffer agreement to use immunity to MCR 6.201 B5. So here is Ms. Shannon Smith's written formal discovery seeking all discovery pursuant to MCR 6.201. So what does that tell us? Where are we now? We know that they offered use immunity to these 2 witnesses. We know that there was a formal request for that discovery, and we know that the prosecution failed to produce those agreements either before or any time during the trial. They came out after, and that was due to, I guess, some public reporting by the Free Press. I believe it was Ms. Baldus' article who first disclosed the existence of the proffer agreement. So we could go back to the proffer agreement, please. That's Exhibit A. So we now know that the proffer agreement actually provides for immunity. If we can move down to 7. It tells us how they can, the cross-examination and rebuttal of inconsistencies. This office may use your client's proffer statement in any proceeding to cross-examine your client. Why is it important? Again, because the prosecution is arguing that this proffer agreement did not provide for any assurances and that it didn't even contemplate that these school officials would testify as witnesses. That, Your Honor, respectfully, is gaslighting, because we can see what the proffer agreement says.
I don't think they said that.
Well, I respectfully disagree. They say right here, there's no promises of favorable consideration. Your client's not entitled to any consideration regarding the charges. It's a gross mischaracterization of the proffer agreements to call them cooperation agreements. They actually do say cooperation agreement. It says cooperation in here. And
It doesn't require them to testify. They could still have not testified.
That's
They
correct.
refused to testify.
That's
right?
correct. They could have not. But here's the point. Here's how they brought these witnesses to the table, to get them into court and to sit in that box to testify. But for the proffer agreements, those individuals could have asserted their Fifth Amendment. And as Your Honor knows, because you said it several times during the trial when there was a dispute about Ms. Crumbley's son testifying, and you told the defense, you're not going to put him up here so he can assert the Fifth Amendment, which is the law in Michigan and always has been. And of course, Your Honor is aware of that because you already made that ruling. The same thing applies here. The prosecution couldn't have brought these witnesses in to testify if they were going to assert the Fifth Amendment. And they had every right to do so, especially considering the overt interest of their deficiencies and failures and whether those deficiencies and failures rose to the level of criminal liability. So if they would have asserted
You mean of Ejek and Hopkins?
Yes. If they would have asserted the Fifth Amendment, Your Honor, they wouldn't even have been here.
Right.
Okay?
Mhm.
And without them, we wouldn't have had any of this testimony about this meeting, this key meeting that this whole case was about, a couple hours before the shooting started, the meeting at the school.
There would have, it's not that there would have been no testimony. there would have been no testimony about what specifically was said at the meeting.
That's correct.
The meeting was 12 minutes long, so there's a video of Mr. and Mrs. Crumbley coming in. There are numerous texts and emails showing that Ms. Crumbley got the picture, that defendant James Crumbley got the picture, and Mrs. Crumbley showed the picture to someone she worked with. There's videotapes that show that Mr. and Mrs. Crumbley were at the school for a total of 12 minutes, and then they left without their son.
Sure.
Right? So
That's
there would be
correct.
testimony about whether or not, from EJAC and Hopkins, about whether or not they were asked to take him home.
Okay, I think I want to kind of talk about something real quick, and I'm going to bring those down. It's driving me nuts. Okay, part of the problem here is when, oh, good afternoon, Journey to Justice. Is it afternoon? It is. It's at 1 o'clock, my time. So, boy, today's flying by. It does fly by when you come in 2 hours later than normal. I kind of on the side of Jennifer Crumbley, although I believe she is partially responsible for what happened because they gave him the weapons. They knew he was mentally unstable, and they still gave him not one but 2 weapons. And but I will say that if there were promises made of to the witnesses, giving them immunity from prosecution for that day and what they said in court, or whatever, it could affect the outcome of the trial. I am all about a fair trial. It's all about following the law. And this is a very good argument. Will they win? I don't think so, but I think it's a phenomenal argument.
Home, whether or not there was discussion about checking the backpack, anything like that, right?
It wouldn't have come in.
There would have been a hole in the testimony.
That's right.
But there would have been other testimony that supported the fact that the meeting happened, that the meeting was brought about by that disturbing picture, text back and forth from Mr. and Mrs. Crumbley to Mrs. Crumbley's friend. There was a lot of evidence surrounding that meeting.
There was, but, Your Honor, most importantly, the school officials offered testimony, very specific testimony about their subjective descriptions about Mrs. Crumbley's actions during the meeting. That could not have come from anywhere else, and that is, in my opinion, thank you. I like when judges say they agree with me.
I know, it really does something for you, doesn't it?
It really does, and only if at the end of the day it means something. But
Oh!
I've read everything 1,000 times, believe me, and I can't unremember these trials.
I believe and understand.
I can't unremember it either.
But the point I'm making is it's not cumulative. So, for instance, in the Chanel case, the People versus Chanel, the 2014 Michigan Supreme Court case.
That's the McDade, right? Chanel 495, Michigan 142.
That's correct.
So, assuming for the sake of argument, I haven't heard from the prosecutor yet today, assuming for the sake of argument that I agree with you that the prosecutor violated the rules of discovery, right?
Yeah.
I need to know what you say the remedy is.
Well,
I agree that credibility is always at issue. If I had $1 for every time I said that, I could retire right now. Credibility is always at issue, and it's clear that the statements of Mr. Ejek and Mr. Hopkins would potentially be used in charging decisions with regard to them. That's clear. But if you go further and reach to know, the difficulty is for the court to find there's a Brady violation, I would need to find not only that the prosecution suppressed the evidence and that it was favorable to the accused, but viewed in its totality, its material, right?
Yep.
And its material, it's exculpatory or impeaching.
that's correct. So that's correct. I agree with that. But in the Chanel case, let's just be clear about why the Chanel case is not a good template to decide this issue. In Chanel, the Michigan Supreme Court said that there was a suppression, there was a violation, but that it wasn't material. Why was it not material in Chanel? Because that witness did not have any sort of cooperation or immunity agreement. And so that witness, there was no basis to attack that witness for bias or motive for what she was saying. I see you want to ask me a question.
Well, if you knew how many times I read this, Okay, so,
And it was also cumulative in Chanel, and it's not cumulative here because they couldn't get those subjective descriptions from anywhere else except these two school officials.
okay, but what part, what would be missing? That she came to the school and she left without Hopkins,
Yeah.
Mr. Hopkins and Mr. Ejek. You still have, she came to the school, she left
Yeah.
the school. She wasn't
So,
with her son. Obviously, no one searched the backpack. Everyone was very disturbed by that picture.
yeah.
And minutes later, right?
Yeah, so here's why it's
And
material.
minutes later, when the shooting starts,
Hello,
Well,
Miss
hours.
Dawn.
hours, 2 hours.
Yeah.
She doesn't think to herself, oh, I'm so worried about the safety of my son. That's not what she thinks.
Well, we don't know. That's what,
She says, Ethan, don't do it.
well, that's after the fact. But I want to back up to the meeting because you asked me, why is that testimony so important and material? It's not just the time people arrived and that they left. Here's what they said. Okay, this is Mr. Ejak testifying that he had an expectation that they would be leaving from the meeting with their son. He said, it seems a little odd based on my experiences. So they were trying to lay a predicate that would satisfy the gross negligence standard that didn't come from anywhere else in the trial, because that meeting is where the prosecutors say Mrs. Crumbley should have done something or taken her son.
Okay, but how is the testimony? There's a difference between the credibility of the witness. I agree with you that the credibility of the witness is always an issue. And, so there would have been robust cross-examination by Ms. Smith, right?
Mhm.
But the problem is, the defense could attack the credibility of Mr. Hopkins or Mr. Ejek based on the proffer and the fact that they knew the proffers would be used in a charging decision, right? But the prosecutor says the problem with that is that the testimony of Mr. Hopkins and Mr. Ejek about the 12 minutes your client was at the school is consistent with what your client said happened at the meeting and still would have been even after robust cross-examination. In other words, that the jury didn't have to believe Mr. Hopkins or Mr. Ejek over your client to convict her. They could believe all three as well as the rest of the evidence and still convict.
I disagree with that, Your Honor, because the prosecution is essentially trying to put us in the box that says the only way we could have impeached those witnesses was with a prior inconsistent statement from the proffer. That's not my argument. That's not my position.
No, I get it. No, it's not a prior inconsistent statement.
I don't,
It's you went and talked to the prosecutor's office and you knew whatever you said could be potentially used in a charging decision, right?
yes.
Yeah, I get it.
Oh, right.
Yeah.
But it affected their
Steva, I
credibility
love
as
your
to these
input. Thank you
subjective
so much.
descriptions about, well, it was odd to me. She was in a hurry. She just wanted to leave. She said she had to go to work. Those are all
She
subjective.
testified, she said, are we done here?
No, she testified, Your Honor. I'm sorry to respectfully, just to correct the court. Mrs. Crumbley testified
Nobody
that,
gave the transcript, by the way.
Yeah.
I got this doorstop, but this is the guidepost report.
yeah, I know. I'm sorry. I gave you so much papers. Mrs. Crumbley testified, page 223 of her testimony. She was asked, did you mean to be abrupt about ending the meeting? I didn't think I was abrupt. Did you think you ended the meeting? I think it just automatically ended. So this is the dispute between those witnesses and Mrs. Crumbley. She couldn't refute.
That's not your brief. Your brief doesn't say
It's right here.
that if we knew about the proffer, the testimony would have been vastly different.
Well, actually, to be honest, Your Honor, I think without the proffers, if they wouldn't have secured the proffers, if those witnesses would have asserted the Fifth Amendment and they hadn't testified at all, Mrs. Crumbley wouldn't even have needed to testify because she wouldn't even have needed to try to rebut these subjective descriptions from the
She
witnesses.
wasn't
That's
called
an interesting thought.
Well, I disagree, Your Honor.
I think she was called humanizer.
Well, perhaps, but there's a twin purpose of it because Ms. Smith, trial counsel, certainly asked, well, did you mean to be abrupt? She says, I don't think I was abrupt. Why is that important?
Okay, but you're arguing that she couldn't have been convicted without Ejek and Hopkins.
Yeah, I believe she could not have been convicted without Ejek and Hopkins. That meeting was key. Let's not forget, the prosecution's theory is that Mrs. Crumbley should have and could have done something at that meeting. And so they portrayed that meeting in a certain light, which was she was uninterested. She was in a hurry. She had to get back to work. She didn't seem to, it was very odd to me. We had other meetings before, but this one was odd. This one was different.
Okay, I'm going to put a little pause here because he's going 100 miles a minute and I need a little brain cramp break. But I will tell you, when I watch this trial, and as I sit here and hear their arguments, and as I recall the trial, if I was I got one too many. If I was a juror, I will tell you that the testimony concerning the school and her behavior and how she reacted truly was, what? Did that happen? For me, truly was impressionable. It left a very big impression on me as to, left an impression. And I think he's right. Without that testimony from the school describing her lack of interest, her need to be out of there, her demeanor, and all of that, I think it would have changed a little bit about how I thought about this case. Would it affected the outcome? Maybe, maybe not. Would she maybe have been found guilty of a lesser? Probably. What are your thoughts on this? If this particular case, if this evidence from the I got to stop doing this so I can think. If the evidence from the school, the testimony from the school was not what it was, and they basically said she came in, we talked, she left, whatever, and we didn't hear all of that intimate details on what they thought, she thought, what their observation of her was, would it have changed your opinion on this case? That is my question to you. I'd love to hear back from you.
Those are subjective descriptions that they can't run from that. And how could the defense contest that? I don't believe Ms. Crumbley could have been convicted without the testimony of EJAC and Hopkins.
And I
because
think that was a
meeting
big part of
was
the
the linchpin
I do
of
too.
the gross negligence insofar as the prosecution's theory was she should have done something then.
Okay, wasn't the linchpin of the conviction, the fact that there was that picture, it was sent to her, there's things all over Facebook about the gun that he got for Christmas.
I don't disagree that some of those
Don't
things,
get caught looking for bullets on your phone.
Your Honor, I believe that those things in part could contribute, but we cannot now parse out after the fact the import of those two individuals' testimony.
But that's the same thing the judge is assuming as well. She gave him the gun, the weapon. Sorry. He's basing his case on assumptions. I don't disagree. But let's look at the assumptions. They did give him the weapon and all that, but the way they reacted or supposedly reacted, we weren't there, so we can't say 100%. But the way they supposedly reacted to that meeting and that information to me was very huge. If we remove that, could she go for a lesser and not what she got? I think so. But the judge is also assuming the what the clinch pin also was on the jury and what they thought was the nail in the coffin. The only way to know that is to talk to the jury, and I don't think they've talked to the jury. I would love to hear from a jury member what was the actual nail in the coffin for her. But I believe that he's making a strong argument. Do I think it's going to work? I don't think so. But I have to tell you, out of any, and I haven't heard as much as some of my other YouTube content creators have because I'm not a lawyer, but I haven't seen too many of these hearings for a new trial that had at least the amount of weight, a possibility of what he's producing. I haven't. Once again, I'm looking at this from a layperson. I'm a criminal justice student. I'm not a lawyer yet. But in my idea, Oh my gosh, it did. I apologize for you. Well, I'm sorry for everybody involved. It was a fascinating case, but Siba, I do believe that there should be some accountability for her, but to have the same level of conviction, I'm not sure. Um, I was glad that she was found guilty when this happened because I do believe she needs to be responsible because I am a licensed, legal, lead shooting, toting mama, and I live in Texas, and that doesn't matter, but, I feel that they were very irresponsible parents, with this child and what they did, and they both need to be, punished. But I do find his argument interesting. Does that make sense? I believe that he has some very good points, but we haven't heard from the prosecution. So let's get going. And I'm so sorry this happened. And I understand you would be very, very biased.
Opposed against the other things that Your Honor is pointing out. So why would they have called those witnesses?
I don't disagree. She was not paying attention to her child. And she was more worried about herself. And I get it. That's why there's many factors as to why I believe she should have some responsibility in this. But to be at the same responsibility level as the son, nah. But anyway, my humble opinion, and I'm sticking to it.
What was the reason? Let's just think about it for a second. What was the reason for calling these witnesses to begin with? Because they could not establish the basis of what happened in that meeting in order to then say to the jury, she could have taken them at the meeting. She could have went and got counseling. And we already know, Your Honor knows, they did not require the parents to take their son. They said, no, he can stay in school.
Okay, but how does that matter? Any parent could come and pick up your child at any time, right?
How does that matter? Well, because
you're
because ultimately the jury was being asked to decide, do you think,
taking him home regardless.
sure, she could have, but they told her she didn't have to, and that there was the plan that he should be around his peers. So they made it optional. But this is where
Actually, the school was actually, if I remember correctly, and Seba or anybody else, if it wasn't what I remember, feel free to correct me. But is it not true that they said that they felt it would be better for him to stay there where they could monitor him and be around other students versus going home, being left alone while his mom and dad went back to work? That is what they alluded to. I'm paraphrasing it. It's not word for word, but that's what their thought was. That's why they didn't insist on him going home. If I was the therapist, if I was working in the school and that happened, I'd be saying, guys, get your son to a psych hospital now. I would have, but the school didn't do that.
they tried to sway their testimony to help the prosecution or say, well, but we thought they would take them. Okay, so you either thought you would take them or you were going to require them to take them. Which one is it? And it's my argument, Your Honor, that the prosecution was unhappy with what some of the statements of those witnesses. So they got up on redirect to try to bolster them by saying, well, what did you think was going to happen? Well, I thought they were going to take it. It was my expectation. That's substantively different. So the reason they called him was because they wanted the jury to hear this moment in time, 2 hours before the shooting. They wanted to focus on what the Crumleys could have done. And what they ended up saying was, well, we thought they should take him. And it was odd. And, you know, she ended it abruptly. She didn't hug her son. Did they hug her son? No, she didn't hug her son. Those are subjective descriptions that wouldn't have come in from anywhere else. The jury was left thinking, well, these two school officials are noble and selfless, and they're just here to tell us what happened without knowing that they were under the threat of prosecution. Let's not forget the prosecution.
They were still under the threat of prosecution.
Sure.
You know, part of the problem is, in your brief is you assume that, or think that if Mr. Ejak and Mr. Hopkins were charged, then that exculpates your client. All four of them could have been charged.
Yeah.
In theory.
Sure.
In theory.
Sure. And a jury also could have said, well, if these guys are facing criminal prosecution, then we should be thinking more about what their failures were. And maybe it wasn't that she was grossly negligent. They didn't know that. So back to my point, the school officials could come in and look noble and say, oh, we're just doing this. And Your Honor, just to remind the court, the prosecutor announced the date after James's verdict that they wouldn't charge the school officials. So why is that important? Because they dangled that carrot over those witnesses to get them to cooperate and to come in.
They were probably never going to charge them.
I agree. I agree they were never. I agree they were never going to charge them, but they had to keep that in place until after the trial. They had to keep.
That is a good point. Knowing before trial that somebody was not going to be charged, and knowing after trial, dangling that carrot in front of the witnesses and letting them assume that if they didn't testify or give the state what they wanted, they too can be brought up on charges. So he is making a good point, in my humble opinion. Y'all, I sound real hollow to me, or I feel very weak. Are y'all able to? This mic stand, I love it, but this mic post sucks. There it is. You are right. You're right. It is all around assumptions. But so is the judges. The son did go before the courts, and the husband, she was the third. But the school, the people who testified on behalf of the school against her and the husband, and all of that, they were not informed till the day after her conviction that there would be no charges brought against them. To me, that's bullcrap. You don't hold that possibility over a witness until after they testify. If you're not going to charge them, and you know you're not going to charge them, you need to tell them before they testify, because they may decide to say, you know what, I'm going to get a lawyer and I don't want to testify and I'm going to plead the fifth. I just think that was a little bit of dirty pool. Would it have changed the outcome? That's all assumption. Seba, I agree. All of these arguments are under an assumption, but we can't go back and know for sure. Everything's going to be assumption. I'm a layperson. I'm looking at this as a layperson. Seba, what do you do for a living? Are you in the legal field? You don't have to be specific. No, it was a day after her conviction. Let me rewind that. I thought it was.
Announced the date after James's verdict that they wouldn't
Okay, it
charge
was
the school
okay.
officials. So
That was the husband. So, okay, you are correct. It is the dad's verdict, but they testified the same way in his case. I just still feel that it's dirty pool. You should have given that information prior to all trials, before the dad. Oh, you're retired? Oh, from what field? Just, was it legal? Because I might want to pick your brain, not necessarily on camera, but I still feel that even in the dad's testimony, they testify. I mean, in the dad's case, James's, that they did testify against him. And I think that they testified against him with the fear and the thought that they were still on the hook. But once they testified in his, they're going to testify in hers. I just think the way they handled the school testimony, and it was brought up before in another format and forum, not here. I was a part of a panel, and I said this here. I didn't like the way they handled the school and the school's testimony in this entire case. No, he did not. You're right. He did take a plea deal. I'm talking about James. He did take a plea deal, and but the father's trial was the first one that there was testimony in. I just don't like the way they handled the school, and I don't like how the school was put off as to not having any responsibility. My father was a teacher. My mother was a vice principal secretary. My father was also a principal and superintendent. He did all of it, and the school does have some responsibility here. Criminally, I don't know. But I get where he's going with this. And he's fighting viciously for his client. kudos to you, dude. We may not agree on it, but I know I'm kind of like up and down and all over this, but my overall impression of this is I felt the prosecution did some things that were inappropriate. But does it warrant a whole new trial? I don't know.
Why is that important? Because they dangled that carrot over those witnesses to get them to cooperate and to come in.
They were probably never going to charge them.
I agree. I agree they were never.
How do you do it?
I agree they were never going to charge them, but they had to keep that in place until after
They didn't know
trial.
that.
They had to keep that threat of prosecution in place until after the second trial and they obtained their guilty verdict. You don't like that?
No, I don't know.
Well,
I
that's-
think they had their hands full with the 2 trials that we did.
if this isn't materiality, that I don't know what could be materiality. And the Chanel case, the suppressed video statement, the suppressed witness statements, as the Supreme Court said.
Oh, yes,
a couple
it
things
was.
that are markedly distinguishable from this case, Your Honor. One, they said it was cumulative. This isn't cumulative, as I've already.
And don't you know that they got transcripts of the testimony of the school in this case because they can, and they can bring that into court in the civil case. So what happened in this case and the testimony and what was said, a large part of this could potentially, and let me know if you disagree with me, Seba. Hopefully I'm saying your name right. I'm very dyslexic and I don't say names right unless I hear them. But I do believe that this could greatly influence. It can greatly influence the case with the civil case. And I do believe that, I don't know if you disagree, and it's okay to disagree. And I'm very much open to the fact that I can be wrong. I'm not always right. As with you, I have an opinion, right, wrong, or indifferent. And if I'm wrong and I'm proven wrong, I'm happy to change that opinion. But I just feel that this whole case wasn't about just her, the mother and father, but it also was setting up for the lawsuit. Even though it was filed before, the information in this case, I believe, could affect the civil case.
Described to the court. What they said about their subjective descriptions was not cumulative of anything else. That's number one. So it wasn't cumulative. Number two, in the Chanel case, they said, well, there were only minor inconsistencies, nothing substantial.
I think
between
it's beautiful.
the statements of the witness and the recorded statements that were not produced. So fine, they had marginal
like
value.
it.
As you're honest, well, their proffer statements weren't really inconsistent. I agree with that. The proffer statements.
So I don't think people realize how much the criminal and the civil actually, the criminal can affect the civil cannot affect the criminal.
Weren't inconsistent, but that only assumes the only way to impeach the witness is by a prior inconsistent statement. That's simply not true. You can also impeach the witness by motive and bias, and that's what the purpose was.
I agree.
So let's not accept the idea that if the proper statements themselves were not inconsistent with the trial testimony, there's nothing to be done here. That's false. That is an incorrect assumption because it has nothing to say about the actual motive and bias of those witnesses, which was absent in the Chanel case because that witness didn't have any proper agreement or cooperation agreement.
All right, what else?
What else? They wouldn't have testified without the proffers. So back to the point.
Okay, but you're.
And then they wouldn't have had that description, the damaging testimony. She was in a hurry. She didn't care. She wanted to get to work.
They have a video.
But not of what was said. We don't have a video of those. Those were subjective descriptions. It couldn't have come from anywhere else except the two witnesses.
What specifically? That's a very small part of the evidence presented.
Oh, I don't think
What
it's,
happened that day.
well, but that's the key evidence. It's the last interaction between the parents and the school officials and the son.
Why is that the key evidence?
Because when they
She
argued,
goes to the school and she leaves the school. Her and Mr. Crumbley.
because they said it seemed a little odd based on my experience. That's page 45 of EJAC's testimony. Typically, he says, he's trying to help the prosecution.
Good question. What did the school have to gain by their own testimony in the criminal case? If anything, it made the school look incompetent. Well, no matter what's going to happen in the civil case, they're going to look incompetent. I mean, so by trying to put the blame on her for not taking this, and the school could say, hey, we did what we're obligated to do. We gave them the option to take him home. We can't force him to stay, and they can't. They can't force him to stay. So by giving her the option of saying, well, you know, he can go home if you want, or he can stay. He can be here with his friends. Once again, there's no recording of the words. There was a video recording of them going in and out, but I don't think was there a recording. Yes. Well, they do to a point have the power to demand the boy to be removed, and they didn't. That is going to be on them. But that power only goes so far. What he did was not, and the school said this in the trial, but I'm paraphrasing here. Basically, there was nothing done other than a drawing. He didn't hand it to a student and threaten a student. He didn't hand it to a teacher and threaten a teacher. He didn't do anything that would give them the right to legally have him removed from school grounds by demand. Unfortunately, they can suggest, you know your son more than we do. This is true. So you can suggest, you can strongly encourage, but there was nothing done at that point against school policy or rules that would give them the power to demand that he be removed, as far as my understanding was.
Typically, parents follow the direction. He says, I did think it was strange they didn't take their son out. That's page 71. The expectation, well, my expectation was that he would be leaving with his parents. Those are all subjective descriptions that only could have come from those witnesses. That your Honor,
Those look like
your
there's
point is,
some
well, we
school
know what time he
attorneys
got
there.
We know what time he left. Sure, we know there was
We
a
know what
meeting.
happened before that, and we know what happened after that.
But the prosecution's theory was, in closing, they were at the meeting and they could have taken these steps at that time, but they weren't interested. They were in a hurry. She wanted to go back to work.
Okay, but
So
they don't need Ejac and Hopkins for that.
I think they do. Because, well, how could they make that argument and say she was in a hurry, she wanted to go back to work without their testimony?
Well, she obviously did not tell them that they gave him a gun for Christmas, and that it was all over Facebook, and that she had heard about the bullets the day before, and that there was that horrendous picture, right? That picture that should be disturbing to any parent that was sent to her. She was so disturbed by it, she showed it to someone she worked with, right? And then she goes there, and did Ejac and Hopkins check the backpack?
No.
But she didn't check the backpack either, right? She didn't check the backpack either.
Well, as we know from at least the guidepost report, the guidepost investigation found that they should have checked the backpack,
Don't be
and
hurt when I tell you we didn't read it.
I won't be hurt
It's
because
not relevant to
it
this.
is 563
It's
pages.
not relevant to these proceedings. And sadly, I know most of what's in there firsthand.
It may not be relevant per se, other than to show the context that these individuals were facing. If the parents were grossly negligent, then the school officials could have been grossly negligent.
Probably.
And the jury could have
Probably.
decided where they wanted to place that amount of blame, whether to reach guilty on the gross negligence.
Good point.
Comparative negligence, civil
Good point.
theory or
No, Your Honor, it's
like, okay, do you think that you were gonna tell the jury, okay, these three all messed up, pick one?
the standard is beyond reasonable doubt, Your Honor. I don't need to tell you that.
You're right. I'm talking behind the bar, not in front of the bar, behind the bar. They're definitely there. Siba, are you part of my Discord? Mod, can a mod, do we have a mod in here? Yes, we do. Mod, can you throw up my Discord? Siba, will you reach out to me in Discord? I have a question for you. Don't worry, I'm not coming after you. I love the way you think. And by the way, Siba and everybody else, if you haven't been here very long with me, I play devil's advocate all the time. What I'm saying here now does not necessarily mean that's exactly how I feel. My job is to see both sides of this fence. Sometimes I do a better job than I am today. My brain had I had a 12-hour night's sleep for the first time in probably over a year, and it was fabulous, but my brain is having a hard time catching up. Hi, Nebraska girl living in New Mexico.
No, that's all they needed to do was create some doubt, and they shored up any doubt that may have existed by virtue of bringing in those two schools. Like, I mean, I feel like what I'm hearing from the court is that this meeting was inconsequential, and I'm reading this.
It wasn't inconsequential, but you're telling me that if there wasn't testimony about what happened at the meeting, or if their credibility was in doubt, which it would have been, their credibility would have been in doubt based on this proffer. You're telling me that if all that happened in the meeting was not presented to the jury, your client wouldn't have been convicted. That's what you're telling me, and I think that's a big leap.
Well,
Convicted
hold on,
or
Your Honor.
on the level
Let's
of
back up.
which?
The Chanel case in the Michigan Supreme Court, they made clear,
Ah,
I
it was
don't have to prove
wonderful.
to you that we would have won an acquittal. I only have to prove there's a reasonable probability that the outcome could have been different. And then Justice McCormick goes on to write what that means. And it means that there's a lack of confidence now, because looking back, we have to say, and Your Honor's pointing out this. Fine, that's fine.
That also means she could have been convicted on a lesser.
We have all these things, but how can you take out that damning testimony from those two individuals, their subjective damning testimony about what they say? Oh, she's in a hurry. She doesn't, this was odd. This was unlike other meetings. That's damaging testimony. So you might right say, well, you had 8 other pieces of evidence, and you're telling me, Mr. Desi, you want to remove the 2 pieces. But isn't 8 enough? No, it's not a sufficiency of the evidence
It's
standard.
whether it undermines the confidence of the outcome.
It absolutely undermines the confidence of the outcome, because they could not have received that testimony of that nature from anybody other than those.
A part of me would
officials.
love to
But this
see a
is-
new trial,
and I've
just
said
for
it a
the
few times, and
giggles.
you're probably going to tell me to stop saying it. These were subjective. These were highly subjective descriptions of what they believed was Mrs. Crumbley's mindset. And that is what the jury heard, with it being unchallenged by the fact that they were highly incentivized to say that to help the prosecution. And as we know, as soon as they
were highly incentivized to not get charged, right?
yeah, absolutely. So, look, we all know how this works. When you have an situation like this, these witnesses are going to do what they need to do. They're going to say, oh, I think they want me to be a little bit more helpful. I think they want me to establish this fact a little better. So
I'm back to, there's no evidence contradicting what they said, and your client's testimony matches what they said.
I don't agree it matches, because,
Well, you didn't tell me you agreed with your match.
well, I'm telling you right now, it's on page
I
220.
don't have the transcript of the trial. It's in my brain permanently, but
I have it if you like it. Your Honor, my brief was 35 pages long. The court roll's only 20 pages. I mean, can I tell you something? My brief was actually closer to 45 pages at
Good
first.
job, everybody.
It
It wasn't a brief.
yeah, it's a oxymoron.
It was
isn't
a book brief.
I'm not looking for praise for my brief. What I'm telling you is, this, now that we're drilled down on this issue of how it could have been contested, right here, Mrs. Crumbley's testimony on page 223, she disputes in principle and in character the testimony that she ended the meeting abruptly. Well, that's important. The jury said, oh, she didn't care. She just wanted to get out of there. She was in a hurry. That's damaging testimony. And if they didn't have any of that testimony from that meeting, then we're left with, he saw something 8 months earlier, and Mrs. Crumbley explained that and said, look, we tell jokes and stuff about this and goes. So the jury could have said, yeah, we believe that part. But now that we understand that these school officials are under the threat of prosecution, we're thinking very seriously about whether to accept their subjective descriptions about what occurred. It's that simple. I mean, this is materiality. If ever there was materiality, this is it. The Chanel case isn't even come close to the facts in this case, because it was minor inconsistencies, it was cumulative, and there was no agreement by which to challenge the witness as being biased or having a motive.
There's other cases that say similar, right? There's other cases
That say similar.
you know, about materiality.
Oh, sure. There's more cases than we probably even need on the law books about materiality, Your Honor,
Yeah,
right?
it's,
If you want, we'll file all of them.
I wrote them.
Well, then you've done more reading than me, because I can't say that I've read them all. You asked me when we started about the remedy.
Is there a remedy if it's not a Brady violation?
Well, just before we get to that, if I could, please. I would ask the court to consider People versus Mumford. This is on page 9 of my motion, Court of Appeals case from 1990. It is axiomatic that the credibility of a witness is an issue of the utmost importance. It is also axiomatic that evidence of a witness's bias or interest
Green Light
in a case is
777.
highly relevant to his credibility.
I agree with that.
And that's the controlling standard. So it is impossible to say that these two witnesses' subjective descriptions were cumulative. It's not cumulative. It didn't come from anywhere else.
Oh, yeah.
So I
You
would
were
ask the
right
court
about that.
to view that.
I think that number one, like he just said, now let's talk about that for a minute, because I think that's pretty much one of everybody's biggest takeaways from this case. And I nailed her butt for it. I did. I came unglued on Jennifer Crumbley. If you don't believe me, go back and watch my coverage of the trial. And I think that Jennifer Crumbley, and he just said it, probably would not have testified had it not been for the testimony of the teachers. Now, I don't disagree with that. I don't know if I agree with it, but it's not a strong disagreement in that. I think that probably would never have been said. She probably would have never been on the stand had the school not got up and testified about her during the meeting. I'm going to set this down. By the way, if you guys who don't know me, I am a Native American bead artist, and I'm making one of these. So if you see me sewing, don't. It's just something to do. I'm a multi-task person. I remember things better when I'm doing something with my hands. I do believe that statement sealed her fate, but Jennifer was and is so disconnected from her son. That is true. Like I said, I don't believe, and this is my own personal belief here. I'm not devil's advocate. I believe she should be held accountable for at some level. Don't disagree with that. But to the level that she was, I'm not too sure. I'm comfortable with that. Do I believe that she would not have testified? And that comment right there would never come out of her mouth had she not been on the stand. We have to look back further, not just at what they're saying, but it's true. The chain of events would have been different. And I think that's what he's trying to argue. He's doing a good job, guys. I have to say he's fighting well. He's scoring some points. He's not scoring some points, but she was very much disconnected. It wouldn't surprise me if she didn't have some kind of a mental health issue, and was unable to handle his. Is that a crime? No. He committed a heinous crime? Yes. Did she give him the weapon? Yes. Was she disconnected and not paying attention? Yes. Do I believe, thank you so much, love. Do I believe that she needs to be responsible? Yes. Do I believe that there may be a need for another trial? I'm on the fence. That's my humble opinion. As you see sometimes in my background, I'm a Joe. I'm a hope. I'm a hope. That's my humble opinion.
Testimony and what happened through the lens of what the Court of Appeals said in the Mumford case, number one. But back to your question now about the remedy. The remedy I'm asking for, Your Honor, is an acquittal. And I have a case cited in my brief. That's the Causey case. It is an unpublished decision from the Michigan Court of Appeals.
Do you really think I'm going to do that?
No,
Okay.
but I want you to, because I think you should. And I think the most important reason why I think that you
Where
should
did you communicate
is
with?
because the violation of the discovery rule in this case was intentional. This wasn't an oversight. And Chanel, it was an oversight, Your Honor, right? You agree?
There's other cases. There's a case that talks about a constitutional violation should be viewed by the quality of the evidence, not by something about character of the prosecutor.
Well, you did say you
I
read
can
more
find
cases
it.
than me, so maybe that's why I didn't read. But can I just make a point about this my request for the dismissal? The remedies generally under Brady generally is a new trial. But in Michigan, we have the specific rule, MCR 6.201, which also provides that the court can take any action just to correct.
Oh, I found it.
Yeah.
If the suppression of evidence results in constitutional error, it's because of the character of the evidence, not the character of the prosecutor.
Oh, I haven't said anything. You've told me I can't talk about the character of the prosecutor. I haven't talked anything about the character of the prosecutor.
You said they intentionally violated the discovery rule. That's what
But this is why I was making the distinction between MCR 6.201 and the federal cases about Brady. Because in Michigan, so Your Honor, Brady and Giglio set the floor as to what the constitutional floor of rights is, okay? Brady was decided in 1963, and it has been the law in the land since that date that the prosecution has to turn over favorable evidence. Michigan can decide that they want to offer greater protections than what Brady offers. So
That's why they get rid of Lester.
That's right. That's exactly right. That's why they get rid of Lester. Your Honor, it's almost so much fun that we're debating these cases.
I don't think so.
You don't? Okay. That's why they overruled Lester. And the point is Michigan the Michigan courts can always
Love
decide
him.
to offer greater protections than those offered under the
Love
federal
him.
case law for Brady and Giglio, which I believe that was what you were reading from. Isn't it?
I think it is from Giglio.
See?
Do you want me
So
to
that
find it?
proves my point, Judge. You're reading from the
No,
gig.
it's from Chanel.
Oh, shoot. Well, either way, we're back to I'm not challenging the character of the prosecutor as much as I'm trying to explain that this was intentional and it wasn't an oversight. And Chanel, the detective, was on the stand and he said, oh, wait, the defense doesn't have these videos? I thought they had the videos. So that was an unintentional or inadvertent suppression.
Okay, but what case says that?
What case is what?
I've had plenty of cases, actually in the past year, 2 different cases, where the prosecutor inadvertently did not provide some evidence. One was ballistics. Guess what? Brady violation. It's
Yeah.
over. There isn't a case that says intentional or unintentional, right? If
No,
there is,
but-
I'd like to know what it is.
Okay, but in Michigan, in the Causey case that you don't like,
I don't like it. Why?
well, you said you don't think I'm going to do that, do you? In Causey, they said that you could do it. In Causey, they said that dismissal is an available remedy.
Oh, you said acquittal. I mean, I guess it's the same.
I think it's the same. So in Causey, the court said that if you're going to consider a dismissal, we have to consider certain factors. And these are listed on page 5 of my brief. That is not brief, as you've indicated. And starting with People versus Al Hiswani, I won't go through these, but there's a number of factors that the court has to consider whether it wants to grant as to the appropriate.
Not as small as the Karen Reed courtroom, I'll tell you that.
Remedy. If Your Honor doesn't accept the notion that a
That case is
dismissal,
unpublished, right?
yeah,
I
it's
know.
unpublished.
And non-binding.
Yeah, you're right about that. We're all going to agree on that too, Your Honor. It's one thing before we leave here, that will be something we agree on.
Thank you, ADHD, and I
But
did
these
get it.
cases, and Leo is also cited in my brief, People versus Leo on page 6, same thing. These cases make clear, People versus Clark also, these cases make clear that the court should balance a number of factors when determining what the appropriate remedy is for a discovery violation. And Causey makes clear that the court can do so independent of whether it finds a Brady violation. Causey says, you know what, we don't have to concern ourselves with finding a technical violation of Brady because in Michigan law, we can rely on MCR 6.201 to offer an additional remedy above the floor that's offered by Brady and Giglio. You like it? You don't like it?
I'm gonna read it thoroughly.
Okay. Would you like to hear anything else from me about the materiality and the proffer
Not at the
agreements?
moment. If I think of it, I'll let you know.
Okay.
All right?
Thank you, Your Honor.
Okay.
And you never did grant my motion to exceed that 20-page limit, although you told me my brief
I
was,
stopped reading it.
oh my, well then, I'm in trouble. I'm sorry.
Okay. I want to take a little breather here. High energy attorneys. Whoa. They get my brain spinning. I will tell you that I think she stopped reading at the 20 pages. I think that's going to be interesting what the defense has. If you noticed, this guy down here has been typing his little butt off. God only knows what he's doing. He could be working on another case for all we know. But in the comments below, will you guys please comment whether you think this attorney did a good job or not? And then we're going to listen to the prosecution side of this. Now, mind you, I play devil's advocate a lot. So unless I'm telling you this is my humble opinion, it may not actually be. I do like to play devil's advocate.
But if we could, just for housekeeping purposes, at some point, make clear that the motion has been accepted.
Mr. Keys.
Judge, there were so many fundamental misstatements of law. and
I
fact
knew
there.
that was going to
I'm
fly.
going to need some time to reply. I will answer any questions you have. Thank
Do you concede that there was a discovery violation?
No, absolutely not. And I want to start off with a few things. And I'd call it
Well,
gaslighting
that's
just
not
now, but this isn't
news.
a game, Judge. It's not a game. Okay.
I'm well
Number
aware.
one,
I'm well aware of that.
the prosecuting attorney made it clear as early as February of 2022 that the evidence that she had reviewed did not support charges of either Nick Ejack or Sean Hopkins as early as February 22. Number two, we can't go back in time to manufacture a new defense when one is not supported by either facts or evidence. I'll get to that later, Judge. Number three, those witnesses were subpoenaed to
smaller.
court. They didn't show up because of a proffer agreement. They were subpoenaed. And the plain language of the proffer agreement
I know,
supports
but
that.
but you didn't say that they had to testify, but they could have still taken the fifth, right?
Any witness can attempt to take the fifth for any reason, Judge. Any witness can. There's nothing regarding the proffer agreements that indicates that the only reason they showed up at court was because of that.
Okay, but why didn't the prosecution provide that information? Maybe we wouldn't be here. I'm positive that decision wasn't an offhand decision by an APA.
Good, Your
I want to
Honor.
read the rest of the court rule that counsel didn't read through. And that's 6.201B5, the entire sentence, Judge.
Yeah,
Any plea agreement, grant of immunity, or other agreement for testimony.
grant of
For
immunity,
testimony.
comma.
There was no grant of immunity,
Is
Judge.
that use immunity?
It is not, Judge. The only way to grant immunity is to petition a court for immunity. It's to contain a verified statement to what these witnesses could be immune from. And the statutes on immunity, that's 767.A7 and 780.701, specify that. They also specify that immunity is regarding testimony. There was no agreement for testimony. I want to give the court a little bit of background.
There was an agreement not to use it in a case in chief if they were charged, right?
Anything they said in that meeting, yes. Yes, Judge. No agreement for testimony, no discussion of testimony. I want to go through the background of that, Judge. First, I want to talk about,
I'm gonna let you say everything you want to say.
thank you, Judge. Jennifer Crumbley was convicted based upon her level of gross negligence because she was the cause of these 4 deaths and because what her son did was reasonably foreseeable to her. Nobody else heard, Judge. That's why she was convicted. Now, the defendant claims,
Well, that's what the Court of Appeals talked about.
yes, Judge, but she wasn't charged or convicted based upon anything that Hopkins or Ejack did. Okay, I want to go through the uncontested
very
evidence,
well
and
may
that
be.
underscores that point. On November the 30th of
Steve, I do
2021,
play.
and I'll be brief.
Well,
Devils.
I hate to interrupt you, but I'm not. Okay, so you've skipped to the Brady violation.
No, I haven't. I'm still in discovery.
Okay, well.
No, you're not. You're tipping into Brady
Should I continue, or
violation.
would you like to ask a question?
I have a question for you.
Okay,
Because you said you didn't violate the discovery rules.
Correct.
Right? And this
Go on,
quote,
Sensei.
stood out to me.
Sensei, go.
Unless indeed the adversary system of prosecution is to descend to a gladiatorial level unmitigated by any prosecutorial obligation for the sake of the truth, the government simply cannot avoid responsibility for knowing when the suppression of evidence has come to portend such an effect on trial's outcome as to destroy confidence in its result. This means naturally that a prosecutor anxious about tacking too close to the wind will disclose a favorable piece of evidence. Didn't the prosecutor tack too close to the wind?
No, and I'll tell you why, Judge.
All right, good.
This prosecution was not premised upon either Crumbley or school liability. That is fundamentally false, Judge. And defense
I'm talking about
counsel's,
a discovery violation.
yes, Judge, it's part and parcel of that, okay?
You're telling me why E.J. Hopkins, Mr. and Mrs. Crumbley could have all been charged and all had their own level of culpability. That's what that goes to materiality. I'm concerned about.
I've got to take a comfort break. I'll
is
be
the
right back.
prosecutor allowed
Hold
to
down the
take
fort,
off the white
Mods.
cap
Thank
for
you.
1 minute?
The prosecutor should follow the law, Judge, and that's
Yeah.
what we did.
Yeah.
That's what we did. The plain language law. That's Sanford v. State from 2020. That's a Michigan Supreme Court case.
Yeah.
For testimony, that's a trailing modifier that applies equally to all three phrases, Judge. There was no immunity. That's the statute. No immunity, Judge. And nothing was offered for testimony. Now, again, I want to go through some uncontested facts. I want to talk about the background of how those proffers came to be. November the 30th of 21, the defendant's son committed the deadliest mass shooting in school shooting in Michigan history, where he killed Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. He used the gun given to him as an early Christmas present and the ammunition the defendant bought for just a few days before. The defendant's son, only friend that this defendant had ever seen around, was taken from him a month before the shooting, and she knew that. The defendant knew her son's proficiency with that firearm. In fact, he showed her how to use it just a few days before the shooting. The day before the shooting, she was called by the school and told that her son was looking up ammunition in school. That's November 29th. November 30th, the day of the shooting, she was called to the school, which all agreed took a great degree of concern, and shown that math worksheet where her son wrote the words, "The world is dead, help, my life is useless." He drew an identical handgun to the gun given to him just a few days before, a picture of a body with a bullet hole and blood. When she was shown that picture, her words, that she talked about her son was distraught the night before. Her words, she said she was very concerned. At the meeting, she was given a list of mental health resources, told to contact that day. She didn't. In that meeting, she only confirmed information that either Hopkins or EJAC gave her. She didn't add any information. She didn't hug or attempt to hug her son. She didn't take him home. All agreed that there was never, you need to take your son home right now. You're forced to take your son home. Everybody agreed to that, Judge. That was never in dispute.
Well, Mr. Kennedy said they went on to testify that they thought it was strange.
Their subjective thoughts and views of that meeting have zero bearing on this case, Judge. Zero bearing. She didn't go home after the meeting to look for the gun. She knew that he couldn't be home alone that day. In fact, she texted her friend just that. And when news of the shooting broke, she knew it was him. Judge, that little snapshot is what is uncontested from November the 30th, that meeting, uncontested from those 12 minutes. Not just proven at trial with the evidence, because that would include a whole lot more. That would include the fact that that firearm was left unsecured and he had unfettered access to it. That would include the fact that she was adamantly aware of her son's deteriorating mental crisis that had occurred some months before. Those facts were proven at trial. But we're talking about just the meeting and what is not in dispute. Because the fact of the matter is that the majority of this case came through text messages, Facebook returns, GPS pings, phone tower records, and surveillance video. That's the bulk of the case. That what happened in that meeting, not in dispute at all. This is not a case of mistaken identity where witnesses had an incentive to identify a shooter as opposed to somebody else, like in Chanel. This is not that case, Judge. The fact of the sheer volume of uncontested evidence underscores that fact. So I want to talk about the proffer agreements themselves.
Do you agree that at the time of the proffer, Mr. EJAC and Mr. Hopkins were subject to potential criminal prosecution and knew it? They were incentivized.
No, I don't agree with that, Judge.
You don't agree with
I
that?
don't agree with that. No.
You don't think they knew? Gee,
They could, I don't know what was in their minds, and it doesn't matter. That's the point. There was intense.
If you had gone in there that day, wouldn't you have thought, geez, I could be subject to criminal prosecution?
I think even Mr. Hopkins testified he wished everything went different. He was the only one to testify that he wished that day had gone differently, Judge, and would have done something differently. Now, the fact of the matter is, after the shooting, in the wake of the shooting, there was intense media speculation, locally, nationally, and internationally, whether anybody in that school would be charged. Some of those individuals were afraid, Judge, I'm sure of it. That's why they retained attorneys. And our job before the preliminary examination is try to meet with everybody we can in those 30 days from the time of the shooting to the time where we had to charge our case and start to organize our proofs. That included individuals at the school. Two of those individuals who retained attorneys, their attorneys reached out to us. And although they were adamant whether their clients wished to cooperate and sit down and speak with us, for the attorney's own sake, they requested the first meeting to be in a proper setting, and we agreed. There was no promise. There was no threat. There was no discussion about testimony. We talked about what they did, what happened November the 30th. And that was entirely consistent with what they told the police on November 30th, 2021.
Wait, let me ask you that because I think I sent an email to both sides. I was a little confused. So the video of EJAC during the profit statement was not provided, but there was an initial police investigation.
Correct.
And the police talked to EJAC, Mr. EJAC and Mr. Hopkins initially, and a police report was generated, correct?
Yes, they were interviewed November 30th, 2021.
Right.
That was recorded by the police. Narrative reports from the sheriff's office were generated regarding those.
Okay, and then when the proffer happened, like, who interviewed them? Did that end up being a police report?
No, it was our office, Judge.
And you just talked to them.
Correct.
Were the police there?
No. I want to talk about that Nick Ejack statement. I will in just a second.
Okay. All right.
Okay. So there was never any agreement or promise for testimony. It plainly does not fit the court rule. And again, that's Sanford v. State. And we'll skip to this part in a second. But even if you were to find that violation, you would still need to find prejudice, which some of the questions you were asking the defense counsel.
Well, don't you think that credibility is always an issue when the defendant is not allowed to cross-examine about the circumstances surrounding the proffer? Doesn't that limit the information the jury may have about the credibility of the witness? Their
credibility didn't matter, Judge. It didn't matter what Sean Hopkins or Nick Ejack did or said. What matters is that Jennifer Crumbley knew all of this. She had 15 years experience with her son, and she got him a gun, and she knew it was unsecured, and she didn't tell anybody. That's not in dispute. And I have gone through that transcript, Judge, and there is no material dispute between Jennifer Crumbley, Sean Hopkins, or Nick Ejack in that meeting.
There's a disconnect. You keep talking about materiality, which is really important, and I'm back on 6.201. Isn't the prosecutor under duty to disclose any information that would affect the credibility of the witness?
6.201, we're talking about the proffer statements themselves. They don't meet that definition, Judge. They don't meet that definition.
All right.
And I don't agree with the point that these proffer statements would affect the credibility of the witnesses. I don't agree with that, Judge. I want to talk about that statement from Nick Ejack. When this underscores the point that it was not for testimony. We didn't call him at preliminary examination. In fact, we hadn't intended.
You didn't call Ejack.
Correct. We didn't intend to call him at all until defense counsel put Nick Ejack on her witness list in December of 2023 and indicated that she was going to call him. We decided we were better off to put him on in our case in chief as opposed to cross-examination. When we made that determination, we should have gone back through the case file and noted that interview instead of work product is now discovery, because that now would have met 6.201, because that would be a statement by a witness, Judge, under the 1999 Court of Appeals case. I forget the name right now. We should have done that.
Ejack wasn't on your original witness list.
He was on the arrest just at witness list. We didn't intend to call him at trial.
Okay.
We didn't need him. We didn't need him in an exam, Judge. Again, because the bulk of what happened on November the 30th at the meeting was uncontested. But before this court even find a discovery violation, this court must find prejudice. And that's where we come back to this faulty misconception that this case was positioned as either Crumbley or the school for liability. The fact of the matter is, any line of questioning, any cross-examination of these witnesses to highlight their own perceived or real culpability would only serve to highlight the negligence on Jennifer Crumbley, because all agreed what was conveyed to her on that meeting. All agreed what she did not convey back to those officials.
Yeah, but Mr. Desi, you put up a black little line, you can read people's minds. Mr. Desi is sitting there thinking, well, we wouldn't even have called her then, right? Because you're saying that her testimony confirmed what Mr. Hopkins and Mr. Ejak said. But Mr. Desi would say that Ms. Smith potentially would not have called Mrs. Crumbley if they did.
The bulk of the uncontested evidence doesn't come from her testimony. She spoke to police as well, Judge. These officers or these individuals spoke to police as well. They testified. They were sued civilly. They testified at civil depositions. Defense counsel trial had that. In fact, she used those questions during cross-examination, and they testified later on in trial. They were consistent all along the way. The uncontested evidence doesn't come from her testimony alone, Judge.
I forgot about the civil depositions. When were they chronologically?
After exam, before trial. I couldn't tell you the date.
Okay.
But we know with certainty that counsel had those because she referred to a page of the deposition during cross-examination. Judge, there can be no I disagree fundamentally with counsel. This is cumulative. This is not cumulative evidence. There can be no prejudice, especially the Nick Ejak statement. It only supports the prosecution theory. It only bolsters it, Judge. There's no inconsistencies there. Now, when we get to Brady, is when we talk about favorability and materiality, because the court is correct. Before a Brady violation is found, you need to show that this evidence is either impeaching or exculpatory, and that a materiality is a reasonable probability that the evidence, had it been disclosed, would result in a different outcome. That is not here. That is not the case here, Judge. There can be no showing of materiality.
Outcome is the confidence in the outcome.
Can you say that again?
I don't know. When we were talking about these cases, this case, like it's not my job to say, oh, I think the jury verdict would have been different. Because that's not my job, right? But my job is to say, do we now lack confidence about the verdict?
Right.
It's a different thing, right?
The standard is reasonable probability that had the evidence been disclosed to defense, the result of the proceeding would have been different. Kyle's talks about, in essence, is this a verdict worthy of confidence? I agree with that. It absolutely is, Judge. Again, this has never been the case. Our prosecution never hinged upon any perceived or real liability on behalf of Sean Hopkins and Nick Ejak. Should they be successfully sued or successfully prosecuted at some point in the future, that would have zero impact on Jennifer Crumbley's convictions, because she was convicted based upon what she didn't tell anybody, what she knew, what she didn't do. The level of uncontested evidence there, that's what speaks volumes. That's what shows and underscores the level of confidence in this verdict. Does the judge have any further questions on this topic?
Not at this exact moment. I'm going to let Mr. Desi respond. And you would like, I'm going to let you respond. I'm going to let everybody say whatever they want. In the end, one side or the other won't be happy that they won't say it.
Thank you very much, darling.
That's fine, Judge. Thank you, Judge.
Mr. Desi?
Your Honor, just a brief detour from the substance of this. I would be remiss if I also didn't tell the court. I have a third law student who isn't here, and I forgot to mention her, and it's important to me that I want to tell you that I also have a third student by the name of Stefania Ilievska, who's also assisted and been working on the case. She's not here today, and she couldn't be here, but I don't want that to be unsaid. So with that, Your Honor, I'd skip back to getting into what Mr. Keith said. He just said, well, we didn't even need Ejak, and we're going to call him. Well, then why did you call him? I'll tell you why. Because, well,
Smith was going to call him.
Well, we're adversarials. We're adversaries, so I don't have to accept his assertion as to why he called him or didn't call
Well,
him.
it would make sense because it was chronology, because Mr. Hopkins talked about what happened in the office, and then Mr. Ejak came by, so
You're not
chronologically.
you're not gonna like what I'm gonna say, but They called him because they wanted him to say that it seemed a little odd. Typically, parents follow the direction. They called him to get those, back to this, subjective descriptions that they could then use as the basis for gross negligence, okay? So, the prosecution's just being absolutely recalcitrant about even acknowledging what MCR 6.201 says, even though we talked about gaslighting and what the husband was trying to do with his wife. They're still saying it's not an immunity agreement. Well, then they don't understand what a use immunity is. If that's the case, respectfully, they're just telling us not to believe something we can see with our own eyes. The subjective testimony is the key. And I know you said you read everything. I don't want to get caught up in my papers.
You don't have
But
to answer,
Mr. Hopkins
Deba.
also
But I
provided
wonder, were
a
you in the
wealth
legal
of
field?
subjective testimony. He had concerns of suicide. That was on, of course, you already know that. I don't have to tell you.
Yes. Yes.
He didn't want him left
Hey,
alone. He wanted him to be
Angela.
seen as soon as possible. I wasn't expecting them not to follow through page 138 of Ms. Hopkins. Why am I telling you this? Because this is subjective testimony that went to the core of gross negligence. But here's my other real dispute with the prosecution and what they're arguing. They're arguing that there's sufficient evidence notwithstanding. That is not the standard. Materiality is not a standard of sufficiency of the evidence. Sufficiency of the evidence just says, well, there's other stuff that would support the conviction. That's not what we're doing here.
Well, that's about the confidence. That goes to whether or not you have confidence in the result, but it also goes to whether or not there's a difference between credibility and teaching of the testimony. So they also say that
Sure.
other evidence provided in the trial supports what Mr. Ejek and Mr. Hopkins said.
Well, yes and no, because the prosecutor also said, oh, there was this, there was this, there was this, there was all of these other things. So what he's suggesting to you is you should find that there was sufficient evidence to support the conviction. And there's just, there's case law. I know I stopped at 35 pages. I told you I already edited out about 10 pages. But I had a lot of case law in there about this exact point. And I took it out because I didn't think we were going to fight about it, or just, I shouldn't say fight. We're not fighting. We're debating the issue of it. But there's lots of case law that says materiality is not dependent on a sufficiency of the evidence. And it's back to what Your Honor said with Chanel. We have to ask, can we have confidence in this verdict, not given the fact that they withheld and suppressed this information? I understand why the prosecutor wants to tell you they didn't have to give the agreements, because it's so obvious the materiality is met in this case. So they're going to go back to square one and say, well, we didn't have to give the agreements. We don't think we needed to provide them under 6.21. We're not going to go back through it because we can read it for our own eyes. So I would suggest that the materiality in this instance is easily demonstrated. I don't even think it's a close call because there was no other testimony about that meeting. And don't forget, the prosecutor stood up in the closing and they mentioned all the things about what they believe Mrs. Crumbley could have and should have done and how she was despondent or disinterested during the meeting. So obviously it was important to them because they elevated it to the point of putting it in their closing argument. I'm sorry I've wandered around. My colleague,
That's
Mr.
a good
Boucher, told me
point.
to stop. I teach and I move all around the classroom all the time, so I can't help myself. He told me to stop, though, Judge, just so you know. All right. If you have any other questions for me, I'm happy to answer them, but I believe that
I don't think I do.
All right.
I mean, anything else, prosecutor?
This is very briefly. I'll keep it very
I
quick.
will let
You've been very patient. I appreciate that, Judge. Now, I just want to, again, hit the point that Sean Hopkins or Nick Ejak's perception of what is odd is simply meaningless, Judge. Simply meaningless.
Ooh,
Jennifer Crumbley
That's
knew the
cool.
background. Jennifer Crumbley knew what that drawing meant. Jennifer
I'm
Crumbley
highly
had the
medical.
opportunity to take her son home.
What?
She chose not to. Jennifer Crumbley should have gone home and looked for the gun. She should have looked in the backpack. She should have put the pieces together. The objective, uncontested evidence is why this verdict is worthy of confidence, Judge. And regarding the proffer statement, again, I just want the court to follow the plain language of the law. That is the law in the state of Michigan. Sanford v. State. For testimony is the operative phrase. There wasn't like there was some roundtable discussion to hide evidence, Judge. It didn't fit the definition, and we never.
hold on, guys. I got to answer this, but I have a good comment.
Revisit it because it just doesn't fit the definition of disclosure. Okay. I don't want there to be any sort of allegation of malfeasance on behalf of the prosecution. And I know the court already indicated that, but I want that to be abundantly clear. Thank you, Judge.
All right, anything else?
Not from the people.
Well, you told me I can't talk about the other things I wanted to talk about, so,
Because it doesn't have anything to do with today.
well,
It
I-
might be of interest in the future, but the prosecutor, for one thing, the prosecutor it wasn't in your brief initially, and the prosecutor wasn't permitted to respond. And I don't know how hiring someone to field questions from the press or PR or any kind of press videotape could impact the decision with regard to the motion that you filed. I'm not saying it might be relevant in the future. I don't know that. But I guess I would say that your job, Mr. Desi, as you know, is to represent your client, persuade me that her position is consistent with the law. And I guess what I'm saying is that information about a PR firm or media coverage won't help me, as I believe it's irrelevant to the current motion.
Just for the record, I just want to point, it's not a PR firm, okay? Again, fundamental misconception, not a PR firm.
I mean, they were social media influencers, Your Honor. Social media influencers. And their own websites say, they tell us in their own words.
The county hired this.
You guys
All right, fine,
can't
Jim.
help it, right?
No, I can't.
Oh my gosh. You could talk to the press about it outside.
Oh, doggy. Did he honestly bring us into this? Okay. I respect that. I may not fully agree with that. I think that in a lot of cases, no, it is not the parents' fault. But when the parents buy him 2 lead shooters, knowing he's mentally unstable, confessing themselves that they knew he was mentally unstable, and they thought by giving him a lead shooter it may help him, I question that. But you're right. The school system does not raise our children. The parents are responsible for their children's behavior. That's why when they hit legal age, I went, phew! I believe he's speaking. Right, very well, maybe, but I want to say this. The problem, one thing I don't think some of us realize, where'd this come from? Came from somewhere. Some of us don't realize, who are not in the educational system, in truth and all honesty, there are a handful of students at every school that are capable of doing what this guy did. So capable, and there are equally the same amount of parents that don't know that. Some do, some don't. But in all honesty, because I talked to a parent of mine who was in the system. Now, my dad's now deceased, but I had birth parents, foster parents, adopted parents, spiritual parents. So I got a lot of them. So what I'm saying is that sometimes parents cannot tell. Sometimes kids hide things very well. Sometimes the parents do know. And I'm not saying that every time a child does what has happened here, that they're responsible. But where I hold her accountable personally, in my humble opinion, which means this is my humble opinion,
I'm sure I know they're very.
I am not playing devil's advocate here, is that they knew of his instability. Now, somebody said, well, she said, I think it was you, Seba, that, or could have been somebody else, I'm trying to find it, that when this had happened, she automatically thought it was her son. Do you know there's a handful of people at every school that have children that if something like this would have happened at their school, they would have thought the same thing. Every child going through depression or mental illness is capable. It's only a split-second decision to do sometimes I'm not putting this as eloquently as I'd like, but I guess what I'm saying is it always can be your child. You could be the best parent in the world, and it can still end up being your child. So to me, I don't believe that every time a student does this, that the parents need to be looked at as responsible. But I do believe that when you know your child has struggling with depression or mental illness, and you hand them a lead shooter, and you know you didn't lock it up, and you don't have control of it yourself, then there is accountability. That is my humble opinion.
Interested in it. I don't think it helps me resolve a motion, so it's not up to me. All
Thank you,
right.
Judge.
So with regard to the defendant's motion for bond pending appeal,
That could be true.
a ruling on this motion is obviously impactful. Therefore, a rule on the motion for bond pending appeal contemporaneous with a written opinion on the motion for acquittal and/or new trial.
All right, fair.
Thank you, Judge.
Right?
Would you be bringing us back then for any?
I haven't decided yet.
Okay, fair
That's
enough.
all I can do to get to this point, Mr. Desi.
I cut my brief down, Your Honor, as much as I could.
All right. So I would like to ask that everyone remain seated while the defendant is removed from the courtroom. All right.
They did, for those of you who are just now hopping on, is my sound coming across okay? Once again, I don't have my hearing aids in, so I'm not feeling the vibration.
Cancel her writ. Oh, yeah, she'll be sent back right away.
Okay.
Maybe today. Maybe today.
Please understand, I don't have my hearing aids in, so the sound is not the same through these ears.
Understood.
But I personally will do it.
I don't disagree with you with that. She was not paying enough attention to her child. Come on. Ow! Dang it! I wish camera people would leave the dang camera alone. I wouldn't stab myself. I'm in beating. I stabbed the crap out of myself. That was a bad one.
All right. What is this?
Oh God, that cameraman sucked. Oh, I get motion sickness easy, and that really drives me crazy. She spent thousands on a horse, but wouldn't spend. Yep. And like I said, in my humble opinion, she is responsible. I am not saying that. I believe there's a level of responsibility that this woman has. I give it that. But on the opposite side of that, how much, was she overcharged? Let me ask this question. This may help me. Was she overcharged? Do you believe that Jennifer Crumbley was overcharged? She did not pay attention to her son enough. She was more worried about horses and other men and having flings. She was not wise in her decision to buy him two lead shooters, and then was very, very frivolous in controlling them and locking them and securing them in a manner in which he could not have access without her ability to remove them or give them to him. I think she got life, but wasn't it first degree, second degree? Somebody look, I don't remember. I'd have to look it up. But I guess what I'm saying here is do you think she should have gotten lesser? Do you think she should have had the same charge? That's in our humble opinion. Do you believe that she was overcharged? Maybe not. Just curious. Okay. We had some new people hop on today. Thank you so much. At the end of today's broadcasting, which now we're going to go over to the California Monica Cinematelli trial. And I hope to see you, Seba, and all you new people, Rachel K, and of course, all my mods. I appreciate Angela and Rachel and Greenlight 777, Kevin, all of you guys. Hello to Britt, Tash, all of you. I hope that you will follow me over there. I do have it to where it should just carry you. I thought it was 10 years. I don't remember. I got to be honest. I thought it was much longer out than that. Maybe it was 30 years with the possibility of parole after 10. I'll look it up. Let me see. Her sentence was 10 to 15 years. Okay. Jennifer and James Crumbley, the parents of Michigan shooters, Ethan Crumbley, were sentenced to 10 to 15 years in prison, found guilty of involuntary manslaughter. Okay. I don't remember. It's been a while. So she got 10 to 15 years. 10 years, she can go up for parole if I'm correct. And but once again, this is a very hot and debated topic. It's about parents having to be held responsible for their children's behaviors. You believe her sentence was equal to her level of irresponsibility? Possibly. Like I said, in my humble opinion, I believe she's responsible. Thank God I wasn't on that jury. That would not be a jury I want to be on. So we're going to keep an eye out for the response to this. It will be interesting. I know I got fuzz on my hat and it's driving me crazy. I do not believe that there's going to be a new trial, in my humble opinion. If there was a new trial, I would be a little bit on the surprise side, in all honesty. Okay, you guys are fabulous and awesome. I have got to take care of something I really need 2 more monitors, and I already got 1, 2, 3, 4 monitors and a computer. I really need 1 more monitor. It's crazy. Giveaway. Okay, that's not what I'm looking for. So I want to thank all of our newbies for hopping in with us. I really greatly appreciate you. I am very blessed to have you here with us, and I hope and pray that y'all have a fabulous rest of your day. I hope that y'all will come on over into the new live that I'm going over to right now. I will start this live before I will go to the next. Oh, shoot. I got to get the food. Hold on. Oh, he got it. Wonderful. My son had lunch delivered. So all of you already served a couple years through the process. Yeah. So she's going to get out. Michigan has truth in sentencing, so 10 years before parole possibility. Yep. Definitely. Let me get started in this other. I don't want to share this tab. I want to enter studio. I need to get going. So now we are zooming over to the California versus Monica Cinematelli trial, where she's alleged to unaliving her husband along with her boyfriend.
And welcome to
We'll see you later.
the Ada
Join me
K
over
Show.
there. And thanks again for joining me.
I am
Bye.
Ada K. Brown.
Have a great
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.